Good afternoon, everybody. Welcome to Disability Rights New Jersey's webinar on special education, transition services, and graduation. Before we start, just a quick disclaimer that the contents of this webinar are for educational purposes only. Nothing in the contents should be considered legal advice. With that said, let's talk about what we're going to talk about today. First, we're going to talk about the basic principles of graduation and transition services under the Individuals with Disabilities Education Act. It's important to discuss the basics of those issues first to make more sense of how COVID-19 has impacted those issues. Then we will discuss some strategies as to how to deal with those issues in light of the COVID-19 pandemic. So we're aware that some people may think the issues discussed during the webinar today are short term, but it doesn't look like the COVID pandemic is going away anytime soon. You're already aware of the toll remote learning took on a student's ability to grow. Recapturing that lost time with students, beloved teachers, and therapists will be a long journey. Also, it is likely we will see more waves and spikes of new cases. So even if schools reopen in the fall, there's always a chance they will close again during the year. Remember that many who have COVID-19 don't exhibit any outward symptoms at all and can still infect others. We've already seen restaurants, bars, and other businesses reopen only to close again when patrons test positive. The reality is we do not know how long the pandemic will last, if it will spike again, or the long-term effects of remote learning, and we need to be prepared. So just a few housekeeping pieces to take care of as we get started. The webinar is being recorded and will be placed on Disability Rights New Jersey's website. We just want you to make sure that you've muted yourself and take yourself off of video as we go through. If you have questions or comments you would like to share with the presenters, there is a chat function within Zoom. If you look along the bottom, you may find the chat button on the toolbar. If you are not seeing it on the toolbar, click on the three buttons, the three dots that say more, and it will open up an entire menu, and chat should be one of the options there. The presenters will be monitoring that throughout, and we will make sure we address those questions at the end. So I see Caroline saying she's having a hard time hearing me. I don't know if anybody else is having the same issue. If someone could just give me a little, oh, Daisy says good, thank you. I appreciate that, thank you. And any of you, anybody who has their video on, I'm about to turn your video off just so it cleans the screen up a bit. Thanks. If you're still having issues, Caroline, check your speakers on your side and see if maybe that might help. And maybe it's an issue on yours. If that doesn't work, you could always log out and log right back in, and maybe that will correct the issue. So we have two presenters today, Robert A. Robinson and Regina Ann Smith. Mr. Robinson, who is deaf himself, has been a special education attorney with Disability Rights New Jersey since 2002. He has represented clients in special education at just about every level, mediation, due process in the Office of Administrative Law, and in federal court. Ms. Smith is a third-year student at Creighton University and currently a summer extern with Disability Rights New Jersey. But she's not your typical extern. She was a special education teacher, having taught students with disabilities in the Collingswood School District. She has also created the transition program for students aged 18 to 21 in the district. So let's talk about the IDEA. As I'm sure you already know, the IDEA requires the provision of a free, appropriate public education, also known as FAPE, for students between the ages of 3 through 21. Because we're talking about graduation here, I need to stress a few things about the meeting of age 21. Generally speaking, a classified student is aged out of special education services if the student's 21st birthday falls on or before June 30 of the student's final school year. For example, if the student's 21st birthday is on, say, June 14th of the school year, then the student is too old to receive more special education services in the following year. Whereas if the student's 21st birthday is on July 5th, then the student can continue to receive special education services for one more full school year. This should provide some parents with comfort knowing that if the child's 21st birthday is in the middle of the school year, the district cannot give the child a diploma on the day he or she turns 21. Make the child clean out their locker and then tell the child to leave school permanently by the end of the day. There's another thing many parents get confused about the age of 21. Many parents think that their children are entitled to receive IDEA services until 21. That is not accurate because the IDEA states that classified children can receive services until 21. That does not mean classified children will receive services until 21. How it is determined when the student is ready to graduate: the IEP team, which a parent and students are members of, determines if and when the student is ready to graduate, which could be well before the student turned 21. How should the IEP team determine when graduation is appropriate? It depends on the student and the student's IEP. Keep in mind that school districts love to graduate classified students. Why? Well, because classified students are expensive to educate, and when a student graduates, the district is financially off the hook for that student. Districts may claim the child is ready to graduate because the child has completed all of the district's academic requirements. However, the IEP team cannot rely solely on completion of credits and coursework for graduation. The team must also consider whether the student received appropriate transition services, like preparation for further education, employment, and/or independent living. We will go over transition services later on in this webinar. Districts also may pressure parents into agreeing to graduate their child because they know the graduation ceremony is a significant event, a rite of passage for students. A request to participate in graduation ceremonies cannot be denied even if the student is remaining in the district or continuing with their education under FAPE. A student can still participate in the graduation ceremony without receiving a diploma, provided the student has completed the district's academic requirements. The state law that allows for this is called Alicia's Law. If the parent feels that the child still has not received adequate transition services, the parent can still file for mediation or due process to invoke stay put to prevent the student from receiving his or her diploma. Now, this is where it gets interesting in terms of procedures for classified students. Generally speaking, an annual IEP meeting takes place near the end of the school year. If the district wants to graduate the student, it must provide what is called an official graduation notice and a summary of performance. The summary of performance explains where the student stands and lists recommendations to help with the student's goals after graduation, like where to get services from DDD or DVRS and so forth. The graduation notice is a specific form that explains 1, the district's decision to graduate the child, 2, the reason for that decision, and 3, the right to file for mediation or due process within 15 days to invoke stay put to prevent the graduation from happening while the dispute is pending. Again, it must be an official form that contains all of that information. Districts might claim that other forms, like sending a graduation packet, sending an email to the parent, or telling the parent in person, serves as official graduation notice that starts the 15-day clock, but that is not accurate. This seems to be happening more frequently of late because of the pandemic, which is making it harder to have IEP meetings. Districts might claim they made a sincere effort to set up an IEP meeting when they have not. For example, they claim they sent several emails or voicemails to the parent but haven't heard back. It is because of these issues you should demand to the district to provide you with an official graduation notice if you're uncertain as to whether the district wants to graduate your child. If the district still does not issue any response to your request for the official graduation notice, then you should file for due process before the graduation date to invoke a stay put. On a special note, students who have turned 21 will age out of the school system at the end of the school year. The student should still receive an official graduation notice. The Department of Education in New Jersey has made it clear students will not be able to continue past 21 even with the pandemic. However, the student may still qualify for compensatory education. If you would like to learn more about compensatory education, please consider joining us for our webinar on July 10th. There is an alarming trend going on with respect to the filing of due process requests. School districts have been challenging the sufficiency of due process petitions filed by parents with a lot of success lately. A district can challenge the sufficiency of due process request within 15 days of receiving it. Districts usually complain that the request does not have all the necessary information, which basically entails the following. A, the name and address of the child, name of the school the child is attending. B, in the case of a homeless child, available contact information for the child and the name of the school the child is attending. C, a description of the nature of the problem, including the facts, and D, a proposed resolution of the problem. We are seeing issues arise with the description of the problem and proposed resolution being labeled as insufficient. They also complain that the parent does not have the authority to file the due process request because the child is now at least 18 and there is no evidence the parent has legal guardianship over the child, or that the child has provided written permission to have the parent file on behalf of the child. The administrative judge has up to 5 days from the district's challenge to decide whether the due process request is sufficient. If the judge determines the request is insufficient, then the judge can A, dismiss the request and have the parent file a new request with all the necessary information, or B, allow the parent to amend the request. However, judges have been noticeably aggressive with dismissing due process requests on the basis of insufficiency. I would not expect the judge to give permission to amend the request. The due process dismissal would be really bad in terms of graduation because the parent can lose stay put to prevent the graduation from happening. Just to clarify, the reason why amending the due process request would keep stay put intact is because the request is still alive. You're just making changes to the request. But when a request is dismissed, it is considered as if it never happened, meaning stay put would not be awarded. Filing a new request would be outside the 15-day window of being notified about a change to placement or services. This gap between the original notice and new filing would be too long to invoke your stay put rights. I'll give you an analogy to help you understand this better. How many of you hate it when your digital clock blinks 12 o'clock after a bad storm? If you want the clock to maintain the right time, you must make sure there is no gap in the electrical supply from the outlet. The digital clock won't automatically stop blinking until the right time, even if the electric supply resumes a second later. Okay, so we'll let Regina, who's going to speak about transition services, take over. But before I do that, I want to emphasize one thing. The need for compensatory education due to the lack of appropriate educational services due to the pandemic could be another reason for the delay in graduation. If the student has aged out or graduated already, compensatory services might still be available. And again, we'll talk about a compensatory education at greater length in our next webinar on July 10th. So hopefully you'll consider joining us. Okay, I'll let Regina take the floor.
Good afternoon, everyone. As a reminder, you can place your questions in the chat box as we move into talking about transition services. So if you have questions about graduation, the pandemic, or transition services, go ahead and put them in the chat box. The IDEA, which had a different name at first, was created in 1975. However, in 1990, it was amended to include provisions for transition services. The reason why transition services were added was because Congress learned that classified students were dropping out at an alarming rate. If they didn't drop out, they were graduating or aging out of the school system without many skills to promote independence in adult life. It became clear that a volcano experiment or analyzing the themes in Macbeth were not going to be enough to prepare students for the future. Transition planning required that schools develop a long-range plan for students to prepare them for post-school life. Amendments of the IDEA in 1997 strengthened these obligations for other public agencies to become involved while students are still in school. This was put in place because the provider's waiting list post-graduation were found to be upwards of 3 years. And that meant that a student graduated and might wait 3 years before resuming any services to assist them. 3 years of sitting at home and not being able to contribute positively to society. Involving the community partners and agencies earlier meant that students would hopefully have a more seamless transition to adult life. So we're going to talk today about some of those community partners for you. In 2004, we saw some of the biggest changes to transition planning, and these are the regulations that are still used today. The amendments mandated what was called a coordinated set of activities. And this meant that all the areas and goals of the IEP had to be connected and implemented together to support students as they move into adulthood. These activities work together, said, with a focus on improving the academic and the functional achievement of a student. It also helped to focus their movement from school to post-school activities. And this was dubbed a results-oriented approach. Basically, this meant 3 things. 1, age-appropriate transition assessments were required. 2, measurable post-secondary goals needed to be based on those assessments and included in the transition plan. And 3, a list of transition services that the student needed to reach the goals was also required to be put in the plan. The plan within the IEP must include the student's strengths, their interests, and needs. This information can come from a variety of sources. The transition statement in the IEP is included when the student turns 14 here in New Jersey. It can be included earlier if the team thinks it's necessary, but it must be written into the IEP when the student turns 14. At 14, though, it's just the academic goals and objectives. So those are the things you're most familiar with because they're used every year in an IEP. They need to connect somehow from school life to adult life. And the district is actually responsible for explaining that relationship between the academic goals and the desired long-term goals. The IEP must include those appropriate, measurable post-secondary goals based on age-appropriate transition assessments. These goals can be related to many things: training, education, employment, and for some students, it even includes independent living skills. I would like to argue that independent living skills should be included for all students. At age 16, it also includes the transition services that are needed to assist the student in reaching those goals. And those services are instructional, they can be your academic classes, community experiences, employment or pre-employment development, and other adult objectives. Some teams might determine that these areas are unnecessary. It's important that the reason is included in the IEP. So you need to ask, how did you determine it was not necessary to offer that service at this time? And then when the district gives you a rationale, ask that to be included in the IEP. If there's a disagreement and you feel that transition services are inadequate, parents or the student can utilize the special education dispute resolution process. And that's mainly located in your prize handbook that you're supposed to get a copy of every year. A transition plan needs to be included every year and should be updated to reflect new preferences of the student and their strengths and needs based on those assessments. The transition plan should not be the same from age 14 to 21. Think back to when you were 14 and then all the way to 21. Did your needs change? Your interests? How about your goals for the future? Mine certainly did, and so we should expect that those plans are updated yearly to keep those changes in mind. So just to review the timeline, the transition statement must be written by age 14 in the IEP, and then the services have to begin at 16. Then there is a required notice of transfer of rights. Transfer of rights must be discussed with parents and the student at least 1 year before the student turns 18. A transfer of rights notification lets the student and the parent know that unless there's a guardianship proceeding, the student will take over and will be able to make certain legal choices about their education. This includes filing for due process. However, a student has the option at 18 to authorize a parent or someone that they trust to act on their behalf with regards to special education services. The student would write a simple letter authorizing the parent. The parent does not need to become an official legal guardian in such a case. But you can see there's a lot that kind of goes on with that transfer of rights. So it's important that the conversation and the notice in the IEP begins 1 year prior to the student turning 18. It's a big change. And with enough time, the team and the student can prepare appropriately. Transition planning team members include everyone on the IEP team. Plus, it can include the Division of Developmental Disabilities and Division of Vocational Rehabilitation Services. So DDD provides the funding for services that assist New Jersey adults with intellectual and developmental disabilities, ages 21 and older, and it assists them to live as independently as possible. Their services are available in the community and also at developmental centers. DVRS can offer pre-employment transition services for students age 14 to 21. And then they can offer a variety of services to the individual with disabilities once they graduate school. They provide services like vocational counseling or placement services, job training, supported employment, skills, or even college training, evaluations, physical or emotional restoration systems, and much more. So if you need a complete listing of all that DVRS is able to do, please visit their website. We have it located in our research section of the presentation today. But please notice I said the IEP team can include these community partners. A student may apply to DVRS and then must be determined eligible. Even if that student is eligible, DVRS will only attend IEP meetings if they're invited by the school and DVRS feels it's appropriate to attend. DDD starts to assess eligibility at 18, but they offer really great informational sessions and educational materials online for parents and students at any time. Whomever is on the IEP team, the student needs to be the captain. IEP meetings prior to age 16 might not have been conducted with much input from the student, but that should really turn on its head once transition services are included. Students should have a huge role in developing their IEP and participating at the meetings. As a parent, you have an important part in the transition assessment process that's decided annually at the IEP meeting. You have a unique perspective about your child, and when you share information with the rest of the team, you really do help to select appropriate tests for the transition assessments. The right test will provide the information that is needed to create a solid plan. Remember, those assessments are used to create the goals. So what tests should be included? The IEP team should select tests and assessments to clarify the interests, strengths, preferences, and priorities of the student. Each child is different, so there's no one mandated test that must be included in a New Jersey IEP transition plan. But some examples could be an informal assessment, like a questionnaire or a survey, a formal observational and performance assessment, like AFLS, the Assessment of Functional Living Skills, or even standardized cognitive assessments like the Life-Centered Education Knowledge Battery. You need to think about your child's knowledge and skills in very specific areas like career awareness, workplace readiness, college and vocational education, and then their activities of daily living, healthcare, physical care, food, clothing. You and the school team also need to consider your child's adaptive behavior. So adaptive behavior and self-determination are what we call soft skills. And those are areas like goal setting, problem solving. The biggest one, self-advocacy, independence of daily living skills, and even communication and social skills. All of these areas can be assessed. And then the results, the data, inform goals. All assessments must be age appropriate. And that term age appropriate refers to the chronological age of the student, not the developmental age. We have seen some districts write transition assessments considered and determined not to be needed at this time. If you see this on an IEP, it is important to ask questions. Remember, assessments are all about data collection. Data inform the goals. If there are no data, where did the goals come from? If the team is going to use assessments that they participate in the classroom, or they don't have additional ones because the academic work covers the assessments, that information should still be documented in the transition plan. So the pandemic has definitely made life challenging, but working toward the goals in transition plans should not be delayed. The plans to work toward the goals will need to be modified, especially if facilities or the services closed, but families and schools should work together. So this might be a really good time to request assessments for transition planning that can be completed at home. You should also document everything. And I know that is heavy and sounds burdensome, but you can ask the IEP team for a simple way to keep track of the progress toward the goals and any problems that you might have had. Ask what can be done to meet those goals in the transition plan. This might require a bit of creativity, but no child should be left with a serious pause in transition services. Recognizing those community partners like DVRS and DDD have also been operating in a different capacity since the pandemic, it might not be possible to have them involved to the extent they were prior to the pandemic. But the Department of Education's guidance said that they should still be consulted and included as much as possible in the virtual shift for transition planning. Some transition services can be provided remotely, just like the academic or related services were. If the student requires daily life skills training, cooking, completing a resume, the instructor could coach the parent on how to build certain skills. Very specific instructions and tasks should be given. And again, recognizing this is no small feat for families. If you feel you are unable to work toward the goals with the instruction given, reach out immediately to the IEP team and document that you contacted them. There are also some really great resources out there. One field in particular, one practice area, is financial skills and growing in your strength for financial skills through free online programs. This is also a really great time to work on using a planner or an online calendar, self-advocacy skills, or even increasing appropriate leisure activities. Some older students have on-the-job experiences that have been paused. These can be replaced with virtual field trips, online work experiences, or volunteer opportunities that can be performed at home, but it's certainly not the same. But remember, one of the biggest reasons for the transition plan and these experiences is to prepare a student for adult life. Online navigation, problem solving, and this pandemic are a large part of our adult life. Occupational training programs at certain vocational schools may also have to be modified during the pandemic. However, some programs do have a mandatory hands-on training requirement in order to qualify for certification or licensure to land a full-time job. And those programs will need to be extended to allow the student to complete those hands-on requirements. So when in-person learning convenes, One thing you should do is request a reassessment or reevaluation of your students' abilities and needs, and then work together with the team to develop a plan for catching up. This might include compensatory services. Whatever the course of study or the transition plan goals, modification might be appropriate. However, it is not okay to suspend or pause services completely. If you believe compensatory education might be warranted, please decide to join us on July 10th, Friday, where we'll discuss extended school year and compensatory education. Thank you.
Okay, so as we move into the questions part of the webinar, please feel free to put them in the chat box. We've had a couple questions that have been dropped in there, and I forward them to Robert, so hopefully he had a chance to look through them. While he's responding to them, Regina, I'll send them to you too. Please remember, take a second, drop a question in there, and we will wait as you type it in, and we'll see what people have to say. Robert, your microphone is muted.
Okay. Oh, okay. I see one question from Amy Ryan saying, can transition services begin earlier than age 16? My answer is yes. Regina, do you agree with that?
Yes, so transition services are mandated to begin at 16, but it's written into the policy that for IDEA that those services can begin earlier if the team decides that it's warranted.
And we have really bright students. So like Doogie Howser kind of students sometimes who can graduate at 13. I believe I would think for students like that, we have to start transition student services at 11. No, I'm just kidding. No, but we have some kids who can start before 16. It would be up to the IEP team. Was there another question?
Bree added a question in the chat box. I wanted to revisit the note that DVR will not attend IEPs unless invited by the school. Does that mean that an invite from the parent or family is not sufficient? And is that policy written anywhere?
So
I'm not aware. Oh, go ahead. Go ahead,
the
Regina.
invitation is usually initiated by the school district, but it doesn't have to be. Remember, your IEP meeting for the parent or the student, they're allowed to invite whoever they need to the meeting. Generally speaking, each district has a case manager that's assigned to DVRS and is really the contact person. So sometimes that's the best way to get in contact with them is through your case manager, but it doesn't have to be that way.
If DDD or DVRS is not doing their part and it doesn't want to get involved, then the school district must have has a responsibility to assume that responsibility. As a transition coordinator, they need to find some kind of way to find some kind of replacement services. And I've noticed that a lot of school districts like to put that responsibility onto DVRS or DDD, and they don't do their part. They don't do their responsibility. Oftentimes, I've seen that in IEPs, IEP meetings, it says transition services, where we are supposed to check who's responsible for those services. A lot of times, I see students and parents being put down as the person responsible, or DDD or DVRS, when the school district is supposed to be the person responsible to do those transition services. And they sort of put that responsibility onto DD or DVRS. I'm sorry, I know my answer went on and on, expensive, but I've noticed this problem happening a lot in transition plans. It's not clear who's responsible to do it, and so the school district puts the responsibility onto the parents.
Another question from Cheryl. Should IEP info on transition services be revised if they continue to be provided remotely or if students can't visit programs?
I think it's a good idea to set up a plan. Outside of the IEP itself, that explains how transition services are provided during this pandemic. Because you want to be able to keep the IEP as if this pandemic never happened. Because if the pandemic is over, whenever that happens, you want to automatically go back to that IEP, have that in place and ready to go.
Great. Any other questions from the group? And as people are typing their questions,
I see one comment.
Go ahead.
From Christine Catano saying the school district had gone ahead with a IEP without her and did not invite a transition school. And when she objected to the school district, they said the graduation notification without the appropriate certification. I have seen that happening. In that situation, it's important to ask for the official graduation notification. And that way you can go ahead and file for due process to prevent that from happening. And another thing, you can file for emergent relief. In general, for emergent relief, you have to satisfy 4 prongs. And you can see that in the parents' rights handbooks, those 4 prongs that you would have to satisfy. But when it comes to stay put, you do not have to satisfy those 4 prongs. You do not have to satisfy those 4 requirements. You only have to do that for official, you get official notification. You have to show that the filing is on time, because you have this 15-day limit. So you have to prove the 15 days, and then you would get an automatic stay put. You would not have to satisfy those 4 prongs first. But of course, you have to make sure that you put down all of the necessary information to make sure the due process is complaint is as complete as possible. Interestingly, if you file for mediation, the school district is not obligated. Well, no, let me say this. The school district can't challenge the sufficiency. That only applies to due process. So they can't make the objection on the grounds of sufficiency. Were there any other questions?
As people are typing their questions, Jeanette just sent a question in asking about a link to the webinar on July 10th. We will forward the link to register for that along with the link to this recording to you either later today or tomorrow morning. So we will record this, we'll place it up on the YouTube channel and on the website. We'll send you a follow-up link with all that information. And then make sure you can sign up for Friday also. Thanks, Jeanette. Any other questions? All right. As people are typing, just in case somebody's typing a final thought, I'll push us to there are some resources in our slides, and what we'll do is we will make sure those are included in the email we send to you as well, which include the Voc Rehab referral form and the DDD timeline for students. So we'll include those links for you so you have them. And then also I'll leave up our contact information at Disability Rights New Jersey. And then Daisy did post the question that just came up, which is, I see students being misplaced in programs quite often. Many of their behaviors are triggered by misplacement. What is the state doing to assist those students?
I would have to ask you, what do you mean by misplaced? Are you saying they're being misplaced into these programs because of the pandemic?
Daisy typed in IEP, so I'm guessing that it's an IEP placement. I'm not quite sure.
In that kind of situation, you should have a functional behavioral assessment called an FBA. And that assesses the behavior of the student and determines why they are having these behavioral problems. Maybe an FBA would not be enough. Maybe they would need the help of a psychiatrist. Maybe there are some problems or issues at home. Maybe they're having some abuse issues or bullying issues, or there are some kind of underlying serious issues behind it. So it really kind of depends on the situation, the student, their background, and maybe a different placement wouldn't be appropriate either. Maybe a full evaluation, psychological, maybe a battery of assessments would be more appropriate. But understand each case is different.
Yeah, and Robert, Daisy added in, their IEPs are not being tailored to
coronavirus in general is causing challenging behaviors for a lot of students. A lot of students with autism, in particular, because they need consistency in their life. And because of this pandemic, they're losing the consistency. And so sometimes they're in a placement that just has to be different. Because they have to be moved up to appropriate grade. They can't just stay put forever. I mean, they can't just stay in one grade, in one situation forever, because a lot of school districts do school up until a certain grade, and then they have to go to another school for another set of grades. And that itself can be a very, very difficult transition for those kind of students. So I would strongly suggest working with the school district to try and find ways that you can transition and make this transition as smooth as possible. But some transitions are just going to be inevitable. Sometimes there's just going to be a new teacher, there's just going to be a new aide, there's just going to be a new environment. And staying at home is not a good solution. It's not a good preparation for challenges that they're going to face. And this coronavirus is really presenting a lot of brand new challenges that have no precedent for us. We can't say, oh, well, last pandemic we did this. We're just learning as we're going along.
Daisy, to your question about the IEPs not being tailored to each individual student, as a provider or someone who's acting right now as a resource for those families, it is important to tell them that every component of the IEP needs to be rationalized, and there needs to be actual data and proof that it belongs in there for that particular student. So even if a student is mainstreamed in math class, their goals for math should still be directly related to that one individual student, not just overarching broad math goals. It should just be the math goals that where their weakest areas are, where they need to show improvement. And so you can direct parents to really make sure when they're going through the IEP with you, that they understand there was a purpose to each of those goals and that they know the reason why those goals or that behavior plan is in there. And if they can't answer that question, they really need to have a conversation with the IEP team to make sure that everyone is on the same page for the individualized plan of that particular student. But Daisy had mentioned in the chat, she sees it most with students who perhaps speak other languages, or there might be a language barrier with the families. And that is something that is really common to happen, especially in IEP meetings, if a translator is not provided. So remember too that there's a right to request a translator to be present for the IEP meeting for the family. And speaking from personal experience, I had families who didn't ask for a translator for years, and had the same student for a few years. And one year we were able to get a Cambodian translator for the meeting, and all of a sudden all of this information came out that I had never heard before. So it is very, very common for language barriers to affect the IEP meeting and making the parents feel like they're part of the team, but that is something that they have a right to request from the school district.
And if you have to go to any kind of dispute resolution, like any kind of mediation, due process, etc., you do need to let the Department of Education know that you're requesting an interpreter. They are the ones who provide an interpreter. I personally, as a deaf person, a deaf attorney, I have to generally provide 2 interpreters for myself. And one time I believe I had a case with a Spanish interpreter, as addition to the sign language interpreters, a Polish interpreter. So the process can take a little bit of time because it's going to go from language to language to language. But that's correct. You have the right to know, the parents have the right to know exactly what's going on in the process during the IEP meeting.
Great, thank you. I don't see any other questions in the chat box. I think we've gotten them all. I want to take a minute and say thank you to everybody who participated today. I hope that this was helpful for you. Thank you to our presenters, to Regina and Robert. Like I said before, we will send you a follow-up email that'll have the link to the recording as well as a link to register for Friday's webinar. So again, thanks for attending. Have a good rest of the day.
Bye, everyone.